Hello friends, Mandar here. I'm back with another video. Today we are going to cover some topics related to EB2 EB3 India or backlog countries, such as travel, what happens when you stay for extended period of time during your adjustment of status, what happens if you come back on advance parole versus H1B, what are the implications and things like that. You never know which question is going to be interesting to you, so watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now in my last India trip, I traveled through one of the destinations in the Middle East. So this is the scene of the airport and I would like you to guess which one it is. If you did guess it, put down in the comment section below, because I'm sure most of you must have visited this place. I also wanted to let you know that I ran a poll on a totally unrelated topic this morning, actually yesterday, and I got some interesting results out of it. It has to do with buying virtual real estate in the metaverse. So a lot of companies are now building video games and an environment just similar to the real world, but in the virtual world, and they are actually selling virtual plots, virtual lands and things like that. So apparently there is an opportunity to buy these things online, and you will probably get to rent it. You'll actually get to collect some royalty out of it, or even sell it at a high price, because they are putting it in a short supply so that they can jack up the price. But I give 4 options and it was interesting to see where people stand on this thing. Now back to our original topic. Now there are a lot of questions that I get on my Patreon site as well as on my email, and before I go any further, make sure if you have any questions or if you want my opinion, that is non-legal advice, it's not a legal advice, but if you just want to get my opinion on your situation, what I would do in that particular situation, you can go to Patreon site. I will leave the link in the description and I'll be happy to answer your questions. Now some of the common questions are the consulates open? Now there have been a lot of groups on Signal platform which are talking about the interview dates coming up or the Dropbox dates coming up. Now there are 2 different things that you got to understand at the consulates. The consulates are actually open and they are doing emergency cases, but because of this backlog that they have built in the last 1.5 years, there is a huge lineup, or there is a long wait period for you to get an interview appointment. Now recently the consulates have declared that they are not going to conduct interviews in specific cases of H1, L1 and so on. I have covered that topic in my last review, in my 2 videos back, so you might want to check that one. But essentially, if you had a visa, similar visa in the past 4 years, you would be eligible for a Dropbox and not have to go to the actual interview. So that is one of the criterias. Now interview appointments is one thing, but there is also something called Dropbox appointment. So there is a long lineup or long wait for interviews as it is, but there is also a wait for the Dropbox appointment. So if you want to know what is the status, you can get in touch with one of these groups online, or you can go directly to the site and see what it is. I think at this point of time you can see appointments few months out. It's all hit and miss, because some days some slot open up because somebody cancels their appointment and then they are taken up very fast. So I know a lot of people are doing refreshes continuously to see if there is appointment available and booking it in the first go. Now whether or not they are able to make it is a different question, and that's where a lot of people have to cancel those and resubmit the request for next appointment. So when these cancellations occur, you can jump on it and try to book it yourself. That is one that I wanted to cover. Now the second question that I wanted to address, and this is very common also, because a lot of people have come to the United States on H or L1 visa, and at some point during their stay in the United States, their company has filed for their green card. So they have gotten to the stage of I-140 approval and they have secured a priority date. Now for whatever reason they have left United States, gone back to India or whatever other country they are living in, and now after several years they are noticing that their date in the EB2 category or EB3 category is now current. Now what do you do in this particular situation? Now if you are still working for the US, if you are still working for the same employer who has the US entity who filed for your original green card application, specifically I-140, it is easier for you to go back and join that company and continue with your green card processing. So that is one option, but for that option you will still need to get on to the an H1 or a L1 visa and then go come back to the United States, work for the same company and continue your application. In this case, if you are able to get an H1 or L1 and come back to the United States, you will be able to apply for something called adjustment of status, because that is specifically reserved for people who are within the country, within the United States. Now say for instance you are not in the United States, you are still outside in India, your date is current and you are still working for the same employer. Now there are two options. One is coming back to US, or the second option is going through the consular processing. Now this is something tricky because now you are expected to receive an invitation letter from the NVC or National Visa Center. Now they keep track of all the I-140s, and when their date becomes current, especially in the family based category, they send invitation letters and then you have 1 year to respond to it. But in case of employment based category, you can be proactive and apply for consular processing if your date has become current. Now again, there are all the other requirements are still the same. You still need to have that bona fide job offer, similar to what was mentioned in your I-140 approval notice when you got that approved. So based on that and your employment offer, you may get your immigrant petition done through consular processing. Now if you don't have that original employer offer letter, you can still go through consular processing. If you can secure another job offer, then that is a tricky situation, because the underlying premise of the consular processing is that it is for the future employment, and if you don't have that job offer, then you cannot base your application on any particular job offer, because at the end of the day this is employment based application. So if you are in India and if your date becomes current, you still need an employment job offer letter in order to go through the consular processing and complete your green card process. So I just thought I would correct that. If you have any further questions in regard to this situation, send me in the comment section below, or reach out to me in the Patreon site so that I will be able to answer it. Now another common question that I get is because of this delay in the processing of the 485. Say for instance you are in the US, you are working for an employer and they have filed for your adjustment of status. Now your date is current, or maybe it's not current. You were able to apply for 485 and now it retrogress, like similar to the example in EB3, which has retrogressed significantly. Now in that situation you are stuck in the US. Now if your employer allows you to work from outside of the United States, say Canada or even from India, now in that situation does your I-485 application remain pending, or does it remain in progress? The simple answer is yes. Although you are technically outside of the country, you were present in the country when you applied for 485. So that's what matters. So if you have to be within the United States when you apply for I-485, because that is the underlying requirement of adjustment of status, that you are adjusting your status while being inside the United States. Now if your adjustment of status or 485 is pending for several months or years, you don't have to remain in the United States. You can go outside for a few months. For if it's significant amount of period, then make sure that you return with an advance parole, because unless you have authorization to travel, which is the advance parole, you should not travel. So that is a technical requirement, because if you just go outside of the United States without the advance parole, it might be construed as abandonment of your adjustment of status. So be careful about that. But if you have your advance parole, you can still remain outside of the United States for a few months and come back, and your application will be intact. Now again, if you are going to be staying outside of the United States even with advance parole for significant amount of time, say more than 6 months to a year, then you will need to notify USCIS about your intent to live outside of the United States, and you have to get specific advance parole or travel authorization to come back when you are ready to come back. Because otherwise, if you have stayed outside of the United States for more than a year, you will have trouble getting back, because they may deem your adjustment of status abandoned. So be careful about that part. Now there is an interesting question, like if you have applied with self-petition EB2 NIW, which is National Interest Waiver, and nothing has happened with your application for a long time, and now if your EB2 priority date is current, can you apply a second application for adjustment of status? You certainly can. And that is true with any EB2 or EB3. You can have simultaneous adjustment of status applied to USCIS, but it can be tricky, because then if both the applications are going at the same pace, and when it's time to allocate your green card number, assuming that your dates are current in both the categories, then USCIS will have to pick one of those, and then they will have extra scrutiny, because now they are seeing two applications, both are current, and they will be have a confusing situation, because now they will say, okay, you qualify in EB3, but you are also saying that you qualify in EB2. So what is exactly going on with your job situation? So you got to be a little bit careful about it. So yes, technically it's possible to have multiple adjustment of status in different categories of visa, but that can confuse a visa officer as to which one is real, which job is real for you. So that it could result in RA fees and things like that. Now talk to a lawyer when you are if you want to have multiple adjustment of status in different EB categories. So that is a tricky situation, and you should carefully assess. Now interfiling is also an option. A lot of people ask me about interfiling. That is a technical provision in USCIS. So you can interfile if your file is in EB3 and now you want to upgrade to EB2, then that is technically possible. But at some point, if you are using those advance parole and EAD card, then you are locked into a certain situation, and then interfile can become a little bit of a challenge. So be careful in that part. If you have specific scenario of your particular case, do discuss that with your lawyer. And if you want my opinion, again, I will be available through Patreon. But again, my response will be only my opinion, and it shouldn't be constituted as a legal advice. Now there is a very common question, and I have covered this multiple times in my previous videos. So say for instance, you are on H1B and you have I-485 application pending. You get your EAD and advance parole. Now a lot of people choose to remain on their non-immigrant status. In other words, they continue to maintain their H1B status or L1 status and remain on non-immigrant status. But the trick is when you travel and come back, and how you join back to a same company or in a new company. Here are a couple of scenarios. If you travel on H1B, your valid H1B stamp, and you come back on your H1B, there is no problem. Your H1B is still intact and you are good to go. But remember, you still have to have your advance parole card in your hand, because otherwise USCIS doesn't know if you have abandoned your application or not. Now in the second scenario is if you are on H1B, you have a valid stamp of H1B, but while coming back you instead of showing your H1B, you show your advance parole. And at that point of time, your port of entry, at the port of entry, you will have that secondary inspection of and then you will be a parolee into the country for the sole purpose of adjustment of status. So that will be your status, but your H1 can still remain intact if you don't update your I-9. So remember, when you join a new employer, there is a process for I-9. I-9 is your verification of your employment status, so whether you are eligible to work in the United States. So if you show that you have H1B, that becomes your status of authorization. But if you show your EAD, then that EAD becomes your status of authorization for work purpose. So even if you come back on advance parole, it is possible that you can still go back on H1 as long as your I-9 file shows that the employment verification is your H1B and not advance parole. Technically, you can choose to go back on, you can choose to go on advance parole or H1B interchangeably but not both at the same time. I'll cover this topic, can I use H1B and advance parole at the same time, in the next video. But remember, just mere by the fact that you have come back on advance parole doesn't mean that you lose your H1B. It is tied to your I-9 and you can still maintain your H1B status. There is a lot of conflicting information regarding this scenario, but in the real world, this is what happens. So again, a lot of things that I tell on this video are from my personal experience or from my experience talking to people. These are not the things that you will hear from your lawyers. But if you have a specific situation and you are still concerned about it, do talk to your lawyers. So that's really what I wanted to cover in this video. If you like the content of this video, please hit the like button and consider subscribing to my channel. And I'll see you in the next one.